planning and all these things. And I'm not an expert, but I brought some experts here, so without, further ado, I want to introduce our speakers, Patricia Scott and her husband, John. And we have Chris Aria, and Melanie, his girlfriend. Yes. Chris is a member of the board at the high school. And Patricia and John, you've probably seen them at Mass at St. Joe's. They're active parishioners, and we're grateful that they're here. So can we give them a round of applause? Okay, welcome.
Good morning. Thank you, Father Steve, for having us here. It's so nice to see so many people. And I just want to introduce myself. I'm Patricia Scott, and I am the principal attorney and founder of Patricia Scott Law. We are a law firm located in Alameda. Our office is right across the street from City Hall. And we focus in estate planning, wills, trusts, post-death estate administration, which is probate. We also handle conservatorships, which are legal guardians for adults that may have lost the ability to manage their own personal care or finances. We also handle disputed estate and trust litigation cases and formation of legal entities such as limited liability companies. I want to, just to be compliant with our rules of professional conduct, say that nothing in this presentation should be construed as legal advice, and we're not establishing an attorney-client relationship. Regarding questions, we are going to pause at various points and ask if anybody has any questions, and we do want to answer your questions, so please feel free to ask them. We also will be, hanging out a little bit after, so if you do have questions that you want to ask us, we will be around to answer some questions. And as Father Steve said, I'm an attorney in Alameda. I graduated from USF Law School in San Francisco, and I worked for several years at Orrick, Harrington, and Sutcliffe, a large firm in downtown San Francisco, in their personal estates group, and then decided to go out on my own, moved to Alameda when our first child was about to be born in 1998. She's now almost 25. And my husband, John, and I have been St. Joseph's parishioners since 1998. And we've raised our 3 children who are now all in college at the same time. We've raised them in Alameda, so this is their home. And also at this time, just ask Chris, my associate attorney, to come up and introduce himself.
Hi everyone, I'm Chris, Patricia's associate. I don't think I've been in this building since I graduated high school here 15 years ago. But I graduated here in 2008. One of the pride and joys of my life was representing my school in athletic competition. I was the #1 tennis player for St. Joseph Notre Dame, went undefeated, 40-0, and won 3 conference championships for the Pilots, 06, 07, and 08. And very proud to have been inducted into the Hall of Fame in 2020. Played in college for UC Davis, played minor league professional tennis without much success, but very much enjoyed it, and made my transition from the tennis court to the court of law. Went to law school at Santa Clara University. I received a very good education there, and then I clerked for the Honorable Judge Stuart Hing in Alameda County Superior Court. Worked on child abuse cases, didn't really enjoy it much. Passed the bar, and I'm very happy to be working with Patricia and serving the Alameda community. St. Joseph community is a very big part of my life, and hopefully I can give back through this presentation and something good comes of it.
Thanks, Chris. Thank you, Chris. I wanted to start out by just acknowledging that one of the things that we have the privilege to see with our clients is that every person, every family has their stories. And we have the privilege of being let into very personal aspects of people's lives, which again is just such a great privilege for us. And so I also want to acknowledge that you may have particular concerns that you come here with, which may be you may be caring for elderly family members or people who have lost capacity in some way, may have memory issues, dementia. You may be concerned about planning for minor children or for planning for special needs children, or you may have recently lost somebody that you loved. And so I know that we all go through those things in our lives, and I wanted to just share with you a little bit about my story, which is how the practice was formed. So shortly after graduating from law school, I experienced the untimely deaths of multiple family members and one of my best friends. So my father died suddenly of a heart attack, and then my mom was diagnosed with cancer. My brother was also diagnosed with cancer. He was 24, and he was subsequently in a motorcycle accident, spent 3.5 weeks in the hospital, and then died. Shortly after that, my mom passed away, and then one of my best friends, who was a housemate that I was living with in San Francisco, got malignant melanoma in her 20s, and she also died. So there were 5 deaths, including one of my dearly beloved aunts, who also got cancer and died, in about an 18-month period of time, which honestly completely rocked my world as a 20-something, child, to be all of a sudden an orphan and, lost a sibling. And it really impacted, after I came out of the shock of it, and informed what I wanted to do with my life. So as I began to recover, I decided that I wanted to use my own experience to walk with people through these types of situations and losses in their life, and use my understanding and knowledge of the legal world regarding these issues to guide people through these difficult transitions in their own lives, as well as to plan to reduce as much as possible conflict, and also minimize difficulty when these events happen, as they usually do. So basically, our goal has been to create a place where people can come, they can share their personal issues with us. We can offer them guidance about making difficult decisions. There's so many difficult decisions that have to be made as part of the estate planning process. And also to provide a safe space, structure, and guidance when eventually, as we all do, you lose somebody that you love. And so often people come into our office after they've lost a loved one, and they feel very stressed and a lot of anxiety because they feel, especially if they're the named executor or successor trustee, they don't know what to do. And part of what we do is say, let us guide you through the process so that you can let go at least of that piece. And so, we've walked through many, many difficult situations with our clients, multiple successive deaths. We go into hospitals and people's homes at very sensitive times when somebody may be on their deathbed. We've planned people's estates, and shortly thereafter they had an unexpected death and then had to walk through with them as they, suffered the death of a beloved spouse or other family member. And again, as I said before, this is just, part of what is such a privilege to us, to be able to be there during these times. The next thing I'd like to talk about is what happens legally when somebody dies. I think that any discussion about estate planning is really best understood if you look at what happens at the end. So, and Chris is going to get into more detail. I'm just going to sort of set up the topic. But if you die in California and you own any assets, really, those assets are going to need to be administered. And what that means is that your assets are going to get passed on to someone after your death. Now, if you don't have any estate plan, so you've never executed any estate planning documents, no will, no trust, no beneficiary designations, then the likelihood is if your assets are over a certain threshold dollar amount, which Chris is going to get into all those details, then your estate will go through a formal court supervised process called a probate. You've probably heard of probate. And in a probate, a petition is presented to the court, an executor or an administrator is appointed by the court, and then the court oversees this process of collecting the assets, paying all debts, paying creditors, taxes, all of that. And then the ultimate end of that is the distribution of the assets. Now, if you don't have any documents, who's going to get those assets? It's going to go to those individuals according to the laws of what we call intestate succession. So in the probate code, it delineates who gets your assets in order. So if you have a spouse, it's a spouse. If you don't have a spouse, it's your children. If you don't have children, and on and on. Now that may very well not be what you intend, right? So how do you prevent against that? Well, you can create a will. And if you have a will, your estate is still going to go through probate if you have over that threshold amount. And I'll just mention that right now in California, that amount is $184,500. So if you have real property, investments, bank accounts, any artwork, other tangible personal property, and your combined assets are over that amount, it's going to go through probate. So the way that most people in California avoid probate is by creating something called a revocable living trust. And a revocable living trust it's a document, but it's a legal entity that you, as the person who creates the trust, you basically give your assets to a trustee. Now, the trustee is typically in a revocable living trust yourself. If you're a couple, it's you and your spouse. And what you're doing is the living trust acts as a will substitute. So all the provisions about who's going to get your assets, who's going to manage the assets if you become incapacitated, who's going to manage and distribute the assets after you die, it's all contained in this document. And it bypasses the probate process because the court does not take jurisdiction over these assets in the event that the trust is properly funded. What that means is that the assets are properly titled in the name of the trust. Chris will go into a little bit more detail about that. But I think the takeaway here is if you don't have any documents, the probate code delineates who gets your assets. If you have a will, you're still going to have to go through probate. And let me just mention that the people want to avoid probate for primarily two reasons. One is because of the time it takes to get an estate through probate, which is typically in California for an uncontested estate is at a minimum 12 months. And what we've been seeing since COVID is more like 12 to 24 months. And it's the cost. So the executor's fees and the attorney's fees are set by statute. It's called a statutory fee at a percentage of the gross probate estate. So you might have, a property worth $1 million and it might have a $600,000 mortgage. Well, the attorney's fees are going to be assessed on that entire $1 million. And so it's much, much more expensive for your heirs if your estate goes through probate because you've also got court costs exponentially more expensive than, setting up a living trust, the cost of setting up a living trust. In that same vein, I want to talk about what happens legally if somebody loses the ability to make their financial and personal care decisions and healthcare decisions. So if you have not prepared any documents and you lose the ability or a loved one loses the ability, functional capacities decline, cognitive abilities decline, and can no longer make decisions, the only way to have somebody appointed is to go through a court proceeding called a probate conservatorship. And probably some of you have had experience with that, with probate conservatorships. What I can tell you from the perspective of handling probate conservatorships is that this is not a road you want to go down because they're extremely expensive to set up. They're court supervised. In order to take certain actions on behalf of the person who's under the conservatorship, you have to petition the court. And this just goes on as long as the person doesn't have the ability to manage their own financial and personal and healthcare decisions. Typically it's going to go on until their death. So it's very, very expensive. It's very, very cumbersome. And the solution to it is pretty simple. It's the execution of documents, financial powers of attorney, healthcare powers of attorney. The living trust will also address what happens during incapacity for any assets that are in a trust. So just to say that, it's a pretty easy fix is what I'm saying. And I think that having that information is really important. I want to just mention before I turn this over to Chris, and this comes from my own personal experience, but also through decades of representing individuals and families, is the experience of grief on the planning and administration processes. So I think our minds are like computers, and we store a lot of information, and I think that the death of a loved one is something that gets stored in our brain. And some of you may or may not have the experience of there's an anniversary of a loved one, and you almost like instinctively or intuitively know like when that's coming up, or like it happens and you're like, oh, that's why I was feeling so out of sorts. And that can actually impact the getting to the estate planning, and I think that that's why it's important just to bring that into some awareness, because sometimes that can be there and sometimes there can be procrastination, which I think is normal for most of us who live in this culture, but just knowing that can be helpful. Regarding the experience of grief on the administration process, it is an enormously difficult time to have to deal with legal, financial, taxes when you've just lost someone. I mean, it's a heroic effort. And so just being aware to remember to create space around that if that's something that you've gone through. And also, that your advisors, your legal advisor, your financial advisor, your accountants, they can create the structure for you to get everything done that needs to be done to take some of that stress off. So with that, I would like to turn things over to Chris, and he's going to get into some more detail about some of these issues. And I'm going to come back in a little bit and talk to you a little bit about charitable planning. So thank you very much.
All right, so I'm going to cover a number of different topics. We're going to start with philosophical attitudes about the eventuality of death. I'll talk more about probate, which Patricia already started talking about. A trust versus a will, conservatorships, revocable living trusts, and the tax consequences associated with estate planning. There are a lot of tax consequences. Gifting to charities or organizations, and then I'll also talk about other important estate planning documents like power of attorney, advanced healthcare directive. So the eventuality of death. The Old Testament tells us that the dust returns to the earth it came from, and the spirit returns to God who gave it. How we typically respond to the eventuality of death. Obviously, there's a fear of death that we all have. Societal avoidance about the topic of death. For some, maybe a bit of a selfish mindset. I'm going to be gone anyway, so what do I care what happens after I'm dead? And this all culminates in procrastination and facing and planning for our eventual deaths. Life is pleasant, death is peaceful, it's the transition that's troublesome. Make your transition from death to life easier by having an estate plan, and respond to the eventuality of death by preparing for it. Replace fear and procrastination with preparation. So what is an estate plan? It's a plan for the management and disposition of a person's assets in the event of that person's incapacity or death. So it's not just planning for death, it's also planning for, the situation where a person may still be alive but may lose mental capacity. Every person should have a plan no matter how big or small their estate is. I've heard a lot of people say, well, I don't really own that much, or I don't own any real estate property, so I don't really need an estate plan. That's not true at all. The benefits of good estate planning is ultimately minimizing conflict and the need for legal proceedings after you're gone or if you're incapacitated, minimizing stress for loved ones and family members, and making your intentions clear. And most people, after they've done their estate plan, they really feel a sense of relief and that they have peace of mind. So it's a big relief to get your estate planning done. So when it comes to estate planning, there are really three basic options, and I'll go through each one of these in turn. The first is don't prepare any estate planning documents and risk probate or conservatorship. The second is that you can prepare a will-based estate plan. And then the third is you can prepare a trust-based estate plan. So neglecting to prepare any estate planning documents risks probate upon your death or conservatorship upon your incapacitation. Under California law, any asset that is valued at $184,000 or more at the time of your death does not have a beneficiary designation and is not in a trust is subject to probate. So I'm going to repeat that again because that's real important. Any asset valued at $184,500 or more at the time of death that does not have a beneficiary designation and is not in a trust is subject to probate. And probate is the court-administered process of reviewing the assets of a deceased person and determining the inheritors of those assets. So certain assets can avoid probate if they have beneficiary designations, but relying on those beneficiary designations isn't always sufficient. So I'm sure some of you have 401ks or IRAs or even bank accounts. You can designate your beneficiaries directly on those IRAs, those 401ks. You can make bank accounts payable on death. And by doing that, you will avoid probate. The problem with those beneficiary designations is they're not always completely reliable. For instance, what if the beneficiary you have named predeceases you? Or what if you've named a child as a beneficiary and they're a minor or a young adult and are not able to manage financial assets? Or what if you're still alive, but you have dementia or Alzheimer's, you can't manage your own finances anymore? Who's going to have authority to access your financial accounts for you, pay your bills for you, and take care of those things for you? So having estate planning documents with clear instructions can specify what happens in these types of situations. Consequences of probate, Patricia got into this a bit already, but probate's time-consuming, takes a year or more, it's public, it's stressful, especially when you're already grieving the death of a loved one. It's expensive, there's attorney's fees, there's executor's fees, court filing fees, probate referee fees. In addition, if you die without a will or a trust, you have no control over where your assets go. Probated assets are subject to the state's predetermined rules of intestate succession. And dying intestate means dying without specifying the disposition of your assets. So this is a chart that kind of shows intestate succession and where do your assets go if you haven't specified anything. And so if you're married or you have a domestic partner and you don't have any estate planning documents specifying where your assets go, then it'll most likely go all to your spouse. If no spouse, then to your kids. If no kids, then to parents, and then if no parents, then to siblings. A lot of people are worried that it'll go to the state. There's a lot of other people in line before it goes to the state. But if it gets more complicated, if you have a spouse and one child, then the spouse will inherit all community property and half of separate property, and the remaining separate property goes to the child. If you have a spouse and 2 children, the spouse inherits all community property and 1/3 of separate property, and children will split the remaining 2/3 of separate property. So I'll discuss later the difference between community property and separate property. But this is what intestate succession looks like. Another consequence of probate are the fees. I have a chart here on the left that shows, based on the value of your estate at the time of your death, what probate is going to cost you. And so for a $1.6 million estate, that's going to cost $58,000 in probate fees. For a $2.5 million estate, that's going to cost $76,000 in probate fees. And that's money that could be going to beneficiaries and loved ones instead if you have estate planning documents in place. And so it's not just probate fees on the left, but it's also court filing and administrative fees, compensation for a probate referee. For a modest $1.6 million estate, it could cost over $70,000 of probate fees. And contrast all these costs with what it costs to set up a revocable living trust, which avoids probate, which is only between $2,000 and $5,000 in most cases. A lack of estate planning documents also risks conservatorship. And so conservatorship is a court proceeding where a judge appoints a family member, a friend, or other responsible person as a conservator to care for another adult, a conservatee who can't care for themselves or their finances. And so there's two kinds of conservatorships. There's conservatorship of a person and conservator of the estate. Often both are needed. And again, conservatorships can be stressful, time-consuming, expensive, especially if who the conservator should be is contested. And a conservatorship can be avoided if you have properly drafted estate planning documents that specify what happens in the event of your incapacity. This is done through a revocable living trust in conjunction with other estate planning documents, a healthcare directive, and a power of attorney. If you have those documents in place, you can avoid a conservatorship. And so for all those reasons I just enumerated, I would cross off the first option of not preparing any estate planning documents. I don't think that's the most prudent thing to do for your estate planning. I'm going to talk about the next option now, which is to prepare a will-based estate plan. And so a will is a legal document that describes how you would like the property distributed after your death. It names an executor as the person who will carry out the testator's formal wishes. The testator is the person whose will it is. And typical duties of an executor include paying outstanding taxes and debts of the deceased person and distributing any remaining assets according to what the deceased person's wishes are. So having a will is better than not having any estate planning documents at all. At least you specified who you want your assets to go to, and so you're going to avoid the whole intestate succession chart and all the default rules of intestate succession, but you're still going to be on the hook for all the probate fees and costs. A will does not avoid probate. It still needs to be reviewed and validated in probate court. Okay, so even if you have a will, you're going to be on the hook for all these probate fees. And so preparing a will-based estate plan is better than nothing, but still not the best option. I'm going to talk next about the third option, preparing a trust-based estate plan. So a revocable living trust is a legal document, basically a contract that allows individuals to continue to own and control their property while they are alive, and then transfer it to whoever they want to after they die, all while avoiding probate. The creator of the trust is the grantor, and they name a trustee and successor trustees to oversee the management and distribution of trust assets. The trustee has a fiduciary obligation to follow the exact terms of the trust and act in the best interests of all the beneficiaries. Most persons will name themselves as the trustee of their own trust while they're alive and they have mental capacity, and then they'll name a successor or multiple successors after they're gone. Your revocable living trust remains revocable and amendable by the trust creator as long as they are alive and have mental capacity, so you can make changes to your trust. And again, assets in a trust avoid probate. And if you do have a revocable living trust, you're still going to have a will. It's called a pour-over will that's executed in conjunction with your trust. But your will basically says that everything goes to your trust. I mean, if there are any assets that you left out of your trust, you want them to go according to what your trust says. So in most instances, especially if you own real estate property, having a revocable living trust-based estate plan is the way to go. Funding your trust. So funding your trust means actually transferring assets into the trust. Just listing assets in your trust document doesn't actually get those assets into the trust. For instance, if you have a bank account that you want it to go to according to what the trust says, you have to retitle those bank accounts in the name of the trust. If you have real estate property, you want to execute a new deed transferring title of the real estate to the name of the trust. And also your trust can be named of the beneficiary of a life insurance policy or an IRA if you want the trust to govern what happens to those funds after you passed away. And a trust is essentially useless if you don't fund it. Failing to fund your trust will basically just land you in probate court. So funding your trust is very important. I'm going to pause now for a few questions. I know we've said a lot, so does anybody have any questions at this point?
Yes. Funding your trust that you're making that comment, how do you actually take money out and just put it into your trust? I mean, if I have a bank account and my husband's on it and I'm on it, wouldn't it automatically go? And then you still have to fund the trust as well?
So the question's about funding a bank account into the trust. So if you have a bank account, and typically with a married couple, it's a joint account, so you and your spouse would both be named as the account holders. You're going to want to retitle the account, so take it out of your names as husband and wife and transfer the name of the account to you and your husband as trustees of your trust. That's how, yeah. That's a process that you go through with your bank. You fill out a form with them, and it's a very standard process that they're used to doing. Yes?
On your chart of the succession, what's next when it said siblings? If someone doesn't have any of that, what's next in line?
If no siblings, Patricia, who's next in line? I'll go back to that chart.
Okay, I always have to look back at the probate code. If there's no siblings, it's nieces and nephews.
Well, if there's none of those either.
Oh, no, okay, so nieces and nephews, and then cousins,
Okay.
and then next of kin. So there is a provision in the probate code for next of kin.
More questions? Go ahead.
So, just real quick, is this where an EIN becomes involved for the trust as as revocable to set up and fund it?
So I'll talk about that more later, but an EIN isn't needed for the trust for a revocable living trust until after a person dies. So all taxes and all income for trust assets, as long as you're alive, is still going to be reported on using your social security number.
If you have an estate plan and you identify who within your family you want things to go to, but you don't want something to go to a certain sibling, is there a way to get that identified so that sibling can't say, oh,
Yeah, the question is about how to make sure a certain person doesn't get any of your assets. And the way you would do that is you would explicitly state in your trust or your will that this person is not to inherit any of my assets, and just make that very clear. Yeah.
When you transfer your real estate into the trust, does it get reassessed?
There's an exclusion from reassessment for transferring property to a revocable living trust. So if you transfer your property to your trust, it will not get reassessed.
So let's say you put your bank account and everything in the name of the trust. Is it still a regular bank account? You put money into it, write check everything out?
Yes, if you transfer your bank account to the name of your trust, it still functions the same way your bank account always does. The account numbers stay the same because you're in control of the trust. And so they're also in control of anything that the trust owns. So the bank account functions as it normally does. It doesn't change that.
You need to get new checks saying a trust account?
You can if you want, but most people don't bother with that. In the back here?
Does the trustees, the estate plan, is that in place of the will, or should you still have a will?
So you either want to have an estate plan that's based on a will or a revocable living trust in conjunction with the will. And so if you want to be sure to avoid probate, it's best to have a revocable living trust.
does a will require a notary or a witness or executor or a current date, something like that to be valid?
To be valid, a will requires two non-interested witnesses to witness it. So two people who aren't getting anything under the will, they have to witness it and then sign as witnesses in order for the will to be valid and helpful.
Does it matter how old it is?
How old what?
Like, I'm saying,
if it was written 10 years ago, is it still valid?
Yeah, a will's still valid for however many years, yeah.
I want to make a comment about
Sure.
I'll get to your question in just one second. I just want to make another comment about valid wills in California. There is another type of will that is valid. It's called a holographic will. So if you write your will, it has to be written in your own handwriting, dated, and signed by you, but it all has to be in your own handwriting. That, and it's not witnessed, that is considered to be a valid will in California. Oh, sure. Yes.
I didn't quite understand the answer that you gave. If you have a valid estate plan, do you also have to have a will?
So the answer, I think the question is, if you have a revocable living trust, you also need a will. Okay, so no. Sometimes we do see revocable living trusts that don't have wills, but we do encounter fairly frequently problems with those plans. And that is that people can sometimes and often do acquire assets after they do their trust. They don't title it in the name of the trust, that whatever asset it is. And that asset has to then go through probate. So what happens? Where does that asset get distributed? Under the laws of intestate succession, because there's no will. So, the court's not going to look at the trust and say, oh, well, they did a trust and this is where they want their assets to go. No. What's going to happen is, that's why you want what we call a pour-over will. And the will says, if there's any assets that I own at the time of my death that are subject to probate proceedings, those are going to be distributed according to this will. And this will says everything pours over into the trust. Yes, sir.
Yes, hi. I just wanted to address an item that you mentioned earlier in your presentation. With regard to a living trust, let's say that you've had one in place for quite some time, 10 plus years, and you decided to make some changes. You don't necessarily have to rewrite the entire trust. You could just simply make amendments. Is that what I understand?
Did you say you're going to talk about that? Okay, I'll just briefly answer that question, which is absolutely. You have the power of revocation, meaning you can terminate your trust or change your trust if it's revocable for your entire lifetime as long as you retain capacity. Now, I will say that most often when we see somebody come into our office that has a 10-plus-year-old trust, there's been enough changes in the laws that trust needs to be redone. Because there's been some very significant changes in the tax laws, so that people were sending up continuing, sub-trusts that basically are no longer needed, that have income tax consequences. So yeah, so typically if you've got an older trust, and also just the world has changed so much, right?
So you would recommend that the entire trust?
I mean, I can't really make any recommendation without looking at the particular documents, but I'm just saying that in our experience, typically if you've got a trust that old, it probably needs to be redone. Yeah.
Maybe one or two more questions, if any. Otherwise, we'll pause for questions again. Yes, in the back there.
If you have a bank account like in the Philippines, will you put it on the same trust that you have here?
Yes, so if you're asking about retitling a bank account in another country in the name of a trust that's established in the United States, that is going to be a question best answered under the laws of that country. I can't say whether or not the laws in the Philippines will acknowledge an American trust or how they'll treat that. I would ask that to a lawyer who practices law in the Philippines. I don't know if the Philippines is going to acknowledge a trust in the United States. I don't know what their laws are. But yeah, that's a good question, though. Okay, I'm going to move on with the rest of the material, and then there'll be more time for questions again. So I'm going to talk about passing on property to a spouse after death. And so there's a law called the Unlimited Marital Deduction, and it's a provision in the Internal Revenue Code that allows an individual to transfer free from any estate or gift tax an unrestricted amount of assets to their spouse during life or at death. So you can pass as much property as you want to your spouse during life or at death, and there won't be any estate or gift taxes. I'm going to talk about the distinction between community property and separate property. So all assets that are acquired during marriage or community property, meaning they're owned 50% each by each spouse. A spouse has power to devise their 50% of the community property any way that they want upon their death. And so even income earned from your job is still 50% your spouse's property, and vice versa. It's community property. So the other kind of property is separate property. So that's any property acquired before marriage, or any property that's acquired during marriage but by virtue of gift or inheritance. That's separate property. And you can devise your separate property any way you want. Your spouse does not have to consent to it. So here are some examples. If you buy and pay off a house before marriage, that's your separate property. Your spouse has no claim to it. If you and your spouse buy a house together during marriage, that's community property, 50-50 each. If you buy a house before marriage and then you and your spouse make mortgage payments during marriage, that house is partially separate property and partially community property. That can get kind of muddy, especially if there's a divorce. Passing on property to children after death. So a lot of times a person will have a minor child. So the question is, what happens if I die and I have young children? How are those assets, how is that money going to get handled? And so usually, if there's a minor child, the property will continue to be held in trust until the child reaches a certain age. For instance, 25 years old. At that point, the child will get all the assets outright free of trust. But until they reach that certain age, those assets will stay in trust, and a trustee will oversee them and make distributions to the child for health, education, maintenance, support, basically necessities. The other important issue with young children is nominating a guardian for minor children. So if you've got young children, you're going to want to name somebody to take care of them if you pass away suddenly, and you can do that through your pour-over will or other estate planning documents. Another important issue is leaving real estate to children, and Proposition 19 is a recent California law that changed how you can leave real estate to children. I'm going to talk more about that in detail. Tax issues are related to estate planning. Benjamin Franklin famously said, "Nothing can be said to be certain in this world except death and taxes." So as a rule of thumb, anytime a real estate property changes ownership, property taxes get to be assessed, and usually the property taxes go up. There was a question about that earlier. There's an exception to this rule if you transfer property to a revocable living trust. There's no reassessment for that. The state wants to encourage people to transfer their properties to their trusts. In 2020, California voters approved Proposition 19. Proposition 19 changed the way children can inherit property from their parents. So this is a big change in the law of California. Under Prop 19, a parent can distribute their primary residence to their child or children, and the property taxes will not go up. The children will continue to pay basically the same level of property taxes that the parent was paying, provided that the child or children live in the property as their primary residence. So I'm going to give some examples of how this rule works. So scenario one, a mom buys a property in Oakland in 1969 for $50,000 and lives there until her death. She pays about $2,000 a year in property taxes. In 2023, the property is now worth $2 million. Upon her death in 2023, mom's trust leaves the property to her son. The son lives in the property as his primary residence. No property tax reassessment. He continues to pay the same $2,000 a year in property taxes. Okay? Now, in scenario two, similar to scenario one, mom leaves the Oakland property to her son. The son lives there as his primary residence. No tax reassessment for that property. But in this scenario, mom also owned a vacation home in Napa that she bought for $75,000 in 1975. When she dies in 2023, that property is worth $2 million. She leaves that property to her other child, her daughter. However, this property was not the mom's primary residence. So under Prop 19, the property taxes are reassessed to current market value, and the property taxes go up to $25,000 a year. The daughter can't afford to keep the property and must sell it. Okay. So this is another Prop 19 example, scenario three. Mom buys a property in Oakland. Same as the first two scenarios, except in this scenario, she has 2 children. She leaves that one property to her 2 sons, 50-50 each. Once one of the sons lives in the property as primary residence, but the other does not. Because one son does not live in the property, his 50% share of the property is to be assessed to current market value, and property taxes go up to $9,000 a year. Okay? There are workaround solutions to these Prop 19 outcomes, but they are complicated and should be discussed with an attorney. But needless to say, Proposition 19 affects how you may decide to leave your real estate property to your children, and it should be, carefully considered. So we've talked about property taxes. Now I'm going to talk about capital gains taxes. When you inherit an asset from a person after they die, that asset gets a step up in basis for capital gains tax purposes. When you receive an asset as a lifetime gift from a person, in other words, while the person is still alive, that asset does not get a step up in basis for capital gains tax purposes. So I'm going to do some examples about how this rule works. So in this scenario, Mom buys a property in Oakland in 1969. It's worth $50,000. In 2023, the property is worth $2 million. Mom dies in 2023, and her trust leaves the property to her son. Son then sells the property for $2.1 million. Upon Mom's death, the son gets a step up in basis on the property to $2 million. His taxable gain is the difference between what the property is worth at his mom's death and what he sold it for. So he's taxed on a $100,000 gain, okay, which isn't too bad. So in scenario 2, Mom decides that she's getting old and sick. She's afraid if something happens to her, she wants her son to be able to be on title to the property. So she executes a new deed while she's still alive, adding her son on title to the property. Okay, so that's basically a lifetime gift. Then Mom dies, and then son sells the property for $2.1 million. Because the son received the property during Mom's lifetime, he does not get a step up in basis. So for capital gains tax purposes, the son will be taxed on the difference between what the mom originally bought the property for, $50,000, and what he sold it for, $2.1 million. So now he's being taxed at a $2.05 million gain, which is a massive tax bill. And all this to say, we should be very careful about making lifetime gifts of real estate property, and should discuss that decision with an attorney or tax person first. So we've talked about property taxes and capital gains taxes. Now I'm going to talk about estate taxes. The current federal estate tax exemption for 2023 is $12.92 million per individual. So if a person dies with less than $12.92 million in assets, then there won't be any estate taxes. That's a high number. It was put into place during the Trump administration. Most states won't owe any federal estate taxes. However, the federal estate tax exemption is set to come down to $6 million in 2026, unless Congress decides differently. And just to note, when Obama was president, the estate tax exemption was about $5 million per individual, and it tends to fluctuate based on who's in power in our administration. The exemption will likely come down in years to come. $12.92 million is unusually high, and in California, at the state level, there is no estate tax. So the estate tax is just a federal thing for Californians. More on estate taxes, portability of the estate tax exemption from one spouse to another. So portability allows the surviving spouse to transfer the deceased spouse's unused estate tax exemption amount to the surviving spouse, as long as a portability election is made on a timely basis through IRS Form 706. And that has to be done within 9 months of a deceased spouse's death. So as an example, let's say the estate tax exemption comes down to $6 million. The spouse dies, and the total value of his estate is less than $6 million. The surviving spouse can file a portability election within 9 months of the deceased spouse's death, therefore increasing her estate tax exemption to $12 million upon her death. So that can be a very powerful tax-saving tool. But the key is to file that 706 within 9 months after the first spouse's death. So income tax consequences, there was a question about this earlier, and this slide is just to say that the way you report your income taxes doesn't change if you have a revocable living trust. You still report taxes using your social security number. The trust assets still pass through to the individual for tax purposes. Gift tax, I'm not going to talk too much about gift tax because, again, the exemption amount is so high. It's $12.92 million per individual. You can make that much in gifts for your lifetime and there won't be any gift taxes. So I'm not going to spend too much time on this topic. Making bequests to charities or organizations upon your death. So I'm going to talk about making charitable bequests in a revocable living trust. I'm going to use SJND as an example since I went to school here. So this is just some sample language I've taken from some trust documents. And this example, as soon as practicable after my death, my trustee shall distribute $100,000 to St. Joseph Notre Dame High School in Alameda, California, with a tax ID number of such and such. Now the problem with making a charitable distribution or any distribution this way is that you specified a specific dollar amount here, $100,000, but what if at the time of your death your estate value comes down to $300,000? So you have a lot of expenses, you need caregiving, something happens. If your estate value comes down by a lot, you could be making an unintended and disproportionately large gift if you decide to do it this way. So there might be a better way to phrase a gift like this, and that's an example too. As soon as practicable after my death, my trustee shall distribute $100,000 or 5% of the net value of my trust estate, whichever is less, to St. Joseph Notre Dame High School. There's another way to do it too, is that you could tier it. As soon as practicable after my death, my trustee shall distribute a gift to St. Joseph Notre Dame in accordance with the following schedule. 5% of the total value of my estate if at the time of my death my trust estate is valued at less than $3 million. 10% of the total value of my estate if at the time of my death my trust is valued at $3 million or more. You can also designate a charity or organization as a beneficiary or partial beneficiary of a financial account or an insurance policy or a retirement account. For example, you can name an organization like SJND as a beneficiary of your IRA after you die, or as a partial beneficiary. For instance, you can name your spouse as a 90% beneficiary of your IRA and then name SJND or another organization as the beneficiary of the remaining percentage. But if you do this, then you'll have to get your spouse's written consent because under California law, retirement earnings are presumptively community property. There are more complicated methods of gifting upon your death. Patricia's going to talk about some of these. I'm going to turn it over to her for a bit.
I'm not going to go into great depth about this. I just wanted to mention a couple of things. And also, I know that we're getting past that 10:30 mark. We are going to go just a little bit over. And, you know, feel free to get up, or if you need to go, that's fine too. So many of our public institutions and private institutions were created using charitable donations. So we are kind of a country that's founded on that. And the one thing I just want to bring to your attention, that there are ways to plan using charitable donations that mitigate both estate and income taxes. So, and this is, I'm putting this out there as a conversation that you may want to think about starting to have with your advisors, your financial advisors, your CPAs, your attorneys. And the reason is because there are ways of donating to charity that can actually reduce your income taxes. And I think a lot of people just don't know about that. There's a way to give, for example, appreciated assets without paying capital gains taxes. There's something called a donor advised fund, where if you have charitable intent, you could, with $10,000 even, donate to a donor advised fund and begin a process of making charitable distributions, and you get deductions that reduce your income tax, in the year of giving or even in subsequent years. There's trusts that are called charitable lead trusts, where a charitable lead or a charitable annuity trust, where you can actually get the income from the trust and the remainder goes to charity. So that what I'm just saying is there are many options out there that people just don't know about that can be beneficial and that can actually allow you to give to charity while also mitigating against taxes. And I think that with the tax rates going up in 2026 and the estate tax exemptions coming down, that this is something that people are going to be more interested in. So turn that back over to Chris.
Okay, we're almost through all the material. Other essential estate planning documents to have, we've talked a lot about wills and trusts, but it's also important to have a power of attorney for finances. So power of attorney for finances specifies who's going to manage your finances, your property. If you're still alive, but you've lost mental capacity, you can't do so yourself. So a trust or a will governs what happens after you're dead. But with the power of attorney, with the Advanced Healthcare Directive, those documents govern what happens while you're still alive, but you don't have the ability to make your own decisions anymore. With the Advanced Healthcare Directive, you nominate a person and also backup persons to make medical and healthcare decisions for you. Who's going to talk to the doctors for you if you can't do so for yourself? Who's going to make important medical decisions for you if you're not able to speak for yourself? Okay? And then with a living will, that's also the medical related document where you specify ahead of time basically whether you'd want life support to be continued for you if you're near the end, or if you want them in crude terms to pull the plug. Reviewing and updating your estate planning documents, there was a good question about this earlier. It's important to periodically review your estate plan and update it when necessary. It's not getting a trust or a will done or doing your estate planning documents. It's not a one and done kind of a deal. At least every couple of years, you should review your trust or your will and make sure it's still in accordance with what your wishes are and it's still in accordance with what the current laws are. Family situations change, financial situations change, the law changes, and so therefore your estate plan has to evolve and change too. It's something that requires constant maintenance. I'm going to talk a bit about unanticipated situations. So a decline in mental capacity. You must have a requisite level of mental capacity in order to execute estate planning documents, otherwise they won't be valid. You know, our office has gotten phone calls at times from children, and they say, oh, my dad needs a trust, or my grandpa needs a trust, come see him. And we'll go to see the person, and he or she's out of it. They don't have mental capacity. Maybe it's dementia, maybe it's Alzheimer's, maybe it's some other mental disorder. But if that's the case, you cannot validly execute estate planning documents. At that point, it's too late to do so. Undue influence is another situation that comes up. So you have to create estate planning documents by your own volition. You can't coerce somebody or force them into doing an estate plan. They have to do it on their own volition and terms. If there is any undue influence, or if somebody is unduly forcing somebody to draft a trust or a will a certain way, that could lead to a lawsuit, litigation. And then unfinished planning. An estate planning documents have to be executed. So in most cases, that means they have to be signed and then notarized. And so even if somebody has a document that looks complete, if it's not signed and not executed, then it's not valid. Okay? So an unfinished draft of an estate plan that's not signed and executed, it's not going to be legally enforceable. And so all this to say that you should do your estate planning while you are still healthy and you have mental capacity, and not procrastinate. How to start thinking about your estate plan. Think about your values, what's important to you. Make a list of all your assets and their approximate values. You know, inventory your assets, whether it's real estate, investment accounts, checking, savings accounts, a business you own, retirement accounts, life insurance, even automobiles. Think about your beneficiaries. Who do you want to inherit your assets after you're gone? And not just beneficiaries, but also contingent beneficiaries, in case the beneficiaries you named predecease you. Think about any organizations or charities you want to leave assets to if you have charitable intent. Think about your fiduciary selections. Who do you trust to manage and oversee your assets if you die or become incapacitated? who's going to be your trustee? If that person can't do it, who's your backup person? Who do you want to be your agents under power of attorney? And who do you want to make medical decisions for you if you can't do so yourself? As an option, there are also professional fiduciaries. So if you can't think of a family member or a friend who can do it, there are professional fiduciaries. They're professional trustees for a living. And that's also an option. And then talk with your trusted advisors, attorneys, your CPA, your financial advisor, because they will all have good input as to how you should structure your estate plan. If you want to talk further or discuss your personal planning situation, my office is available. We offer complimentary consultations, and we will offer discounted fees for everybody who attended today's seminar. And there's our contact information there, phone number and email, and then at this point we will open it up for questions.
Before we take questions, I just want to make a couple comments about the handouts. So we did leave some handouts, as I said, over on the table over here, and I just want to explain a couple of them. So there's an article from the American College of Trust and Estate Counsel from back in 2008, which is a really touching article about a doctor who was terminal and left something called an ethical will for his children. It's very, very touching. I encourage you to read it. And this is a whole nother topic, and maybe, we'll come back and do it. We want to come back and actually talk in more depth about charitable issues, and, we can also touch on ethical wills, but there are websites, people are writing letters to their loved ones. These things have so much meaning to the people who are left behind. To get communications from their loved ones that were created up, when they were still alive. So that's just something for your information. I've also left 2 other handouts. One of them just is sort of a trigger to have you be thinking about the kinds of communications that you would, who's in your circle of important people in your lives, and what communications do you want to make to them? And again, that's just for your use if you would like to use it. And then there's another one that definitely needs explaining. It's called a loss history graph. So earlier I talked about how grief impacts us in terms of both planning and administration. One of the things that I learned in my grief coursework is that, you'll remember I said our mind is kind of like a computer. And, when somebody dies, it's like it triggers memories of every single interaction we've ever had with that person. So one of the things that we were taught to do was to plot on a graph every memory, kind of sequentially in chronological order, just as a way to, think about and remember that person as a way to sort of help with grief. So I just, again, put that out there for your use. So any other questions? No. Yes.
How do you find a professional fiduciary?
Good question. Well, there is an organization of professional fiduciaries in California, and they have a website, and you can also contact us because we do have relationships with many professional fiduciaries that can, point you in the right direction to get that information. I think it's called the California Licensed Professional Fiduciary Association. And like I said, they have a website, and they're active in California.
So does that mean that any person that's on there is just fine, or how do you tell what's a good one and what?
That's a good question. Yeah, I sort of inadvertently rolled my eyes. So my experience is that most of the professional fiduciaries are wonderful. Just like in any profession, it kind of runs the gamut. So again, if you are interested in a professional fiduciary, reach out to us. We actually, work with some very, experienced and ethical. Having them be ethical is very important.
You can recommend one.
Yeah, we can recommend. Yes.
I have a question. As far as like the contingent person, what exactly that person is out of the country, and of course they don't have a social security number, which is very important here. How does that work? I mean, what information do you need from them besides their name and I guess their address?
Yeah, that's a good question. So that's going to be we have dealt with those situations a lot. I mean, I had one situation where there was a beneficiary in Eritrea, and they had a whole different system, and getting that distribution to that particular beneficiary was complicated. So I think that that's probably a situation that, we want to address directly. In a consultation, we'd probably be able to sort of flesh out what the best way to do that. But we do have, many of our clients have family members or friends who are in, in other countries. And, you definitely want to make sure that it's safe, that it gets to them in the best way possible. I know there's tax issues and things like that. So that's something that we'd have to sort of flesh out.
Why would somebody choose to do the lifetime asset gift rather than like a revocable trust, considering a case like maybe?
Oh, right. You mean like giving their house during lifetime? Yeah, I mean, I think that's a good question. There can be reasons to do that legally. So, and this was more so before the laws changed, but sometimes people are trying to protect assets from recovery by the State Department of Healthcare Services if somebody received Medi-Cal, for example. Or they're trying to actually qualify for some type of public benefit like Medi-Cal. So that can be a reason that people do it. Also, sometimes I think they just have a thought or somebody's told them that it's better to do it during lifetime. We've had people come to us. We've actually had to undo a couple of those transactions recently, where there was actually a reassessment because of that. One of the comments, does that answer your question? One of the comments I wanted to make about Prop 19 is what the former law was. So formerly before this, from 1986 until now, if you were able to transfer property from parents to children or children to parents, principal residence 100%, no requirement of living in the property, and other real property up to $1 million of assessed value. And I'm talking assessed values, not fair market value. So usually the assessed values are a lot lower. So Prop 19 radically changed the landscape in terms of, increasing property taxes where there's transfers of real property from parents to children. So, we had to recently kind of try to undo through the county one of those transactions where somebody transferred their property to their child and they weren't living in the property and the property got reassessed. So, yeah. Yes.
If you have assets in different states, how will that?
Yes, good question. So, revocable living trusts are cross-border for the most part. Wills are not. So if you have assets in different states, typically you can retitle them into the name of your trust so that there's no probate on your death. I mean, possibly there could be issues with certain states, but I haven't seen them. So typically that's going to work. Now, if you move out of state, that's kind of another question. You could have a California revocable trust, but that raises certain issues. You probably also want to have other documents in the other jurisdiction. Yeah. Yes.
Before my mother passed, her tax representative told her, because she had a substantial amount in the bank, that she could gift her children. And so it was up to $15,000. Is that changed in California?
No,
Yes.
that's a good point. There is something called on the gift tax side. There's something called the annual exclusion. Right now, I think it's $16,000 per donee. So basically, you can gift to pretty much anyone per donee per year $16,000 without needing to file a gift tax return. So, and I also wanted to make one other comment about beneficiary designations and retirement accounts, just to keep this in mind, which is something that we go over in our consultations. But actually, because of tax reasons, it's actually better to name beneficiaries on retirement accounts. And this has to do with stretch out of payments. Although we do structure our trust to make sure that you get the tax benefits of being able to pay out to the beneficiary over 10 years. I'm just gonna flag this as an issue to, you don't necessarily always want to name your trust as a beneficiary under a retirement account beneficiary designation. Having it go to individuals is often a good idea, just for tax reasons. Yes.
If you have a 401 retirement account
and you want to give it to 3 charitable organizations, can you do that?
Absolutely. Yes. Yes.
Does the trust have to be prepared in the state you live in or die in? I mean, if you move states, do you have to redo the trust?
Well, again, I think that's, should be discussed on a case-by-case basis. Legally, your trust is going to be cross-border.
Oh.
Yes. Yes.
If you have extremely expensive medical procedures that keep going on, if my home is in the trust, is it safe from,
Is right, you're talking about creditor protection, I think, right? Okay. Well, I think that's one of those questions that would be really important to discuss in the context of all the particulars going on. But what I'm going to tell you just in general, a revocable living trust is not going to protect your assets from creditors. There are different types of trusts, different mechanisms for creditor protection, but a revocable living trust is mainly a probate avoidance mechanism and a will substitute. So creditors can usually reach your trust because it's revocable. Yes.
Yeah, something you mentioned earlier with regard to retirement accounts and beneficiaries. So you mentioned you should name beneficiaries on your retirement accounts, and to make that entire process ironclad, should you also just name the beneficiaries on the revocable living trust as well? I'm just wondering. I just want to get some clarity on that.
Yeah, so in general, if you create a revocable living trust, you've really created a very well thought out plan about where you want your assets to go and certain contingencies that might happen. So you should transfer your assets to your trust, pretty much all of them. I mean, you may continue to hold a joint account with your spouse, a small joint account that wouldn't end up going through probate. Now, the exception to that can be, and we have to evaluate it in the context of the person's kind of personal, family, and financial circumstances, is retirement accounts. And the reason is retirement accounts are governed by federal law. And there's something called the Secure Act, which allows distributions out of that retirement account post-death to your designated beneficiaries over the course of 10 years. So the funds are continuing to grow tax-free, and minimum distributions are being made, right? So unless you have a properly drafted trust, if you name your trust as a beneficiary, it's possible that there would have to be a lump sum distribution at the time of your death or over the course of 5 years. But there is a chance, that's, fairly good chance that what's going to happen is that the tax benefits will be lost. And that's why I say that in general, naming individuals or charities or whatever on your beneficiary designations for retirement accounts is best. With other assets, a taxable investment account, put it in the trust, don't use beneficiary designations. Beneficiary designations do not take into account contingencies. That's the problem, right? You've got minors, minor is named, you have to set up a probate guardianship in order for the assets to be distributed to the minors. I mean, it just will create all kind of problems. Right?
If your primary asset is in your 401k retirement account, and you leave it to somebody specific, and that's mostly where your money is. And now you die, and you talked about the expenses that need to be paid. But now you've given it to somebody else. So then, that sounds like a challenge.
That can create a challenge, yeah. Yeah, that definitely can create a challenge if there are not other assets to pay for expenses of administration. Yes. Yes.
Yeah. Can you designate to a minor child a certain amount for their retirement account?
I mean, you can pretty much do whatever you want in your, it's your assets. If you want to have a distribution to a retirement account for a minor child, I don't see a problem with that. Yep. All right, well, one more question here.
I want to know if you do this. I know people who have made it interstate where money goes to a charity, in this case, a scholarship. But somehow it's self-funding and perpetuity, and I guess off interest, and it's just ongoing.
I think what you're talking about is some kind of continuing charitable trust. And
It supports itself and it's ongoing.
right.
It's just you spend it, it's gone.
Exactly. So yeah, I mean, there are some rules about, in California, there's something called the rule against perpetuities. And so, trusts can exist only for so long, but we're talking about more than 100 years. So, I mean, there's kind of specific issues that we have to address about that, but you can create a charitable trust or a charitable foundation or, yeah, absolutely. All right, thank you so much, everybody, for coming. Really appreciate it.
So thank you again to Patricia and Chris. Not only are they very knowledgeable, but they're very nice people, And when it comes to